I'm very grateful to be here, and I thank the organizers, sponsors, this wonderful university, all of you. Robert Alexy's work has been significant and influential and controversial in an impressively wide range of fields across disciplines and jurisdictions. This talk will focus on one small corner of his work, his discussions regarding what he calls law's claim to correctness. One can divide the issue roughly into three parts: what it means for law to claim anything, whether the law claims correctness, and what follows if it does. I'll take on each set of issues in turn before concluding. The assertion that law claims correctness might sound strange, especially to those not already deeply into jurisprudential discussions. After all, the law, understood as a particular legal system, is not a person. So the law claims X may to some ear sound as absurd as saying the law ate steak for dinner last night. In the words of Neil McCormick, quoting here, to say law claims anything meaning this literally is a category mistake. There's no entity, law, which is capable of performing speech acts of this sort, end of quote. One standard response is to clarify that talk of law's claims is just a shorthand for the claims legal officials make on behalf of their legal system. Perhaps that is what Joseph Raz was getting at when he stated, quoting here, the claims the law makes for itself are evident from the language it adopts and from the opinions expressed by its spokesman, end of quote. More to the point is John Gardner's argument that it is in the nature of legal officials, that it is part of what it means to be a legal official, that these individuals make claims in the name of their legal system. In his most recent work, Alexy also appears to adopt this position, equating law's claim with a claim by, quote, its representatives, first and foremost the lawmakers and judges with their decisions, end of quote. Of course, in this sense, this solution merely pushes the question back one step. Just as a legal official purports to speak on behalf of the law, I might assert that I am making claims on behalf of this table or of my car. It would still be mysterious what it means to say that my table or my car were claiming anything through me or otherwise. However, with reference to the claims of law, it is not like an anonymous practice of attributing views to furniture. To the contrary, we regularly attribute agency to governments in other contexts. For example, in the decision to wage war, or to declare a national policy. This is not to dismiss the strangeness of such attributions, but simply to note that one cannot dismiss agentic characterizations of some parts of government while accepting it for other parts. For the purpose of this discussion, we will accept the idea of law as claiming, and we'll move on. Alexy asserts that to be legal, an individual norm or a system of norms must claim correctness, and that a legal system or legal norm that did not succeed at being correct and authoritative would be, for that reason, defective. This claim of correctness carries obvious parallels to Joseph Raz's well-known claim that law by its nature necessarily claims authoritative status. However, Raz takes this point as consistent with his exclusive legal positivist theory, while Alexy believes that his comparable claim ultimately requires an anti-legal positivist conclusion. Both Alexy and Raz believe that the claims ascribed necessarily to all legal systems are consistent with a particular legal system being unjust in the extreme. Perhaps matters are different in the original German, Richtigkeit, but in the English translation, correctness seems to be a somewhat unusual thing for a legal system to claim. If I were teaching a class and offered a calculus equation or the formulation of Boyle's law regarding the relationship between the pressure and volume of a gas, the idea that I implicitly claimed that these equations were correct would make some sense. However, law is not, and legal rules are not, mathematical or scientific formulas. It's true that Ronald Dworkin once claimed that for legal disputes that come before the court, there were always or almost always unique right answers. However, even assuming that Dworkin was correct, he was speaking about questions before a court or some other forum, where there is a question about what the law is, and so it is natural to speak of, for example, whether the court got it right or not. There is much less of a yes, no, or correct, incorrect sense when lawmakers pass legislation, though such a declaration would not be entirely inappropriate. We do say that legislatures say took the wrong path in responding to urban violence or are doing the right thing on climate change. In one work, Alexy explained the legal claim to correctness as follows. Here I'm quoting, "This claim is not concerned with the absolute rationality of the normative statement in question, but only with showing that it can be rationally justified within the framework of the validly prevailing legal order," end of quote. One might respond that justification here is similar to correct. It is a term that ranges widely, likely exceeding what the author intended to communicate. Perhaps it would be helpful to consider matters from a slightly different context, let's say commercial activity. Imagine a business doing some action, buying back its stock, selling its products at a high price or perhaps a low price, dumping hazardous waste into a local waterway in violation of the law, threatening to move to another country as a negotiating tactic to persuade its employees to accept low wages, and so on. Are these actions correct? Can they be justified? Obviously, one likely needs more facts for each instance, but suffice it to say that correct and justified in terms of maximizing profits and shareholder value would be a quite different evaluation from correct and justified in terms of what is morally best or morally acceptable. Alexy's view, his assumption in this discussion, is that justification means moral justification, what Rawls elsewhere described as justified normativity, justified by objective and universally valid reasons. More recently, Alexy has stated that the claim to substantial correctness is, quote unquote, first and foremost a claim to justice, end of quote. Even this is not as clear as it at first appears. Here, just appears to be equated, perhaps with a nod to Radbruch, with not clearly unjust, and correct with not clearly incorrect. One needs to be careful here. Just because justice or morality does not require the promulgation of a particular rule does not mean that a rule that was promulgated cannot be thought of as justified by reasons. For example, there are good reasons for regulating automobile travel, including the imposition of reasonable speed limits. It may be that in a motorway, 120 kilometers per hour is as reasonable a speed limit as 130 kilometers per hour. The selection of either would be justified by reasons. This view, not especially controversial, is consistent with the view of many theorists, including Finis on determinatio and Alexy on the broad range of what is discursively possible. Within the range of acceptable rules, each rule is justified by reason, even if the choice among the acceptable rules is, in a sense, arbitrary. However, there are undoubtedly legal rules in most legal systems that are, at best, superfluous, not necessary to solve a collective action problem, not necessary to coordinate behavior, not a needed element of a general plan to respond to some injustice or some need. Such rules might be justified in two senses. Procedurally justified in that they were passed by proper procedures by institutions acting within their delegated powers, and two, substantively justified in that they are not unjust, or at least not extremely unjust. Still, others might argue that most rules infringe on liberty in some way, and if they cannot defend that infringement by adding to the common good, then they are in fact unjust, even if only unjust in a small way, and therefore not justified. John Gardner argues that if the law makes claims, the claims law makes must be moral claims. He sees this as the only alternative to the more straightforward view that law makes, after all, legal claims. Claims that X has a legal right, Y has a legal duty, and so on. Gardner's argument is that a claim must be capable of being true or false, and law's claim that X has a legal right would not be capable of being false. This argument has initial appeal, but it depends on an overly simplified understanding of legal claiming. First, the legal system as a whole rarely declares X has a legal right. As mentioned earlier, if any claims or declarations occur, they occur through individual officials. As regards claims like X has a legal right, judges and courtrooms are usually the source of such declarations. And in such contexts, it is not problematic, or at least it is significantly less problematic, to characterize instances of such proclamations as being potentially mistaken. It is entirely commonplace to say that in a particular case, the judge got it wrong regarding the attribution of legal rights and duties. The whole process of appeals depends on the coherence of saying that one judge got it wrong and other judges corrected the outcome. To be sure, if and when a dispute is finally resolved by the highest court in the jurisdiction, there is a sense in which the legal system as a whole has made a claim about legal rights. With the apparent finality of the highest court's ruling, one can perhaps say that X has a legal right is the view of the law. However, even here, the usual practice is to think that this claim of X's rights might still be mistaken. Such accusations of mistake are made not only by disgruntled academics and activists, but also on occasion by the courts themselves, at least in those jurisdictions where courts have the power to overrule their prior decisions. For example, in the case of the United States, the Supreme Court has, on a number of occasions involving racial segregation, forcing children to salute the flag, and the criminalization of homosexual sex, famously rejected its own precedent and declared the court's prior decisions to have been mistaken. Also, one might note that the legal system, legal rules, generally do not declare rights and duties. They establish sanctions to be applied in connection with some behavior, rewards to be offered for other behavior, and the rules empowering individuals regarding certain processes and statutes. And such prescriptions are not truth-apt in a straightforward way. John Finnis offers a different analysis. He argues that law claims only to be reasonable, controlled by reasons. But were it to claim to be morally obligatory non-defeasibly, in parallel with its claim to be legally non-defeasibly obligatory, it would be, I'm quoting Finnis here, embody a moral error and assert a moral falsehood. This is because laws are by their nature general. And even for generally just legal systems, individuals may sometimes have moral reasons to act contrary to what the law prescribes. Elsewhere, Finnis offers that is, quote, it is possible that some legal systems abstain from claiming to be morally obligatory, unquote. Returning to the claim of correctness, consider some of the examples Alexy gives to illustrate and support his conclusion. In a constitution, X is a sovereign, federal, and unjust republic. By a judge pronouncing the sentence, the accused is sentenced to life imprisonment, which is an incorrect interpretation of the prevailing law. Alexy describes assertions of this sort to be performative contradictions. That is, the express content of the propositions are said to contradict claims that are implied in the nature of the proposition or the context of the utterance. The conclusion that these statements are in fact self-contradictory likely follows if one already accepts the idea of a necessary claim to correctness, but it is less obviously the case if law involved no such necessary claim. Let us further explore the idea of performative contradictions in general, and in particular its application to the area of legal norms. It may be useful to start at related but more basic ideas. For example, under one standard understanding of truth, for any proposition P, to assert P is true is not different from simply asserting P. This then ties in with what is sometimes called Moore's problem or Moore's paradox. But one cannot sensibly say regarding proposition P, P is true, but I do not believe it. Sometimes linguistic acts also have implications or presuppositions. One example is a promise. Connected to or entailed by a promise to do something is an implicit claim that the promiser believes that the action ought to be done. Regarding norms, Rotolo and Roversi suggest different possible performative contradictions in legislation. For example, where a legislature might purport to enact some legal norm while simultaneously declaring that improper procedures were followed or that the legislature was acting outside its authority. These are arguably more straightforward examples than Alexy's, as the declaration of improper procedures or inadequate authority go to the power of the institution to do what it purports to be doing. I have argued elsewhere that Alexy's analysis confuses a general point about language and advocacy for something peculiar to or essential to law. If one is trying to sell or persuade or encourage behavior, one uses positive language. To not in some sense claim correctness very broadly understood, in any context that calls for support or persuasion is, at least initially, paradoxical. You should buy this product, but it's not very good. Vote for me, I am the least qualified of the candidates. Or I order you to do X, but you probably shouldn't do it. This is a point about language and rhetoric, not about law and morality. And let us focus first on Alexy's unjust constitution example. Most constitutions do not expressly say anything, one way or the other, about whether they are correct or incorrect, just or unjust, legitimate or illegitimate. As Bulegin says, quoting here, I very much doubt that all legal authorities claim that the norms are morally correct or just. At least it is very doubtful in the cases of Caligula or Nero, and yet it is hard to deny that there was a legal system in Rome under those emperors. End of quote. One might say that examples from Nero or Hitler or Stalin are not true counterexamples, for while we see their efforts as clearly unjust, these evil leaders did not come out and declare the injustice of their laws publicly. However, one could imagine the following variation. What if a country were to say in its constitution or some other official forum the following: we have no time for so-called justice. That is the talk of weak countries. Our nation is all about commercial efficiency and doing the best we can for the citizens of our great nation. In this era of semi-authoritarian populist politicians all around us, I fear that such comments are only too easily imagined. Would a country's public dismissal of justice mean that its rule system would not warrant the label law? I'm not convinced. Alexy might respond, surely a government or rule system that does not purport to be following some conception of justice, to be seeking some conception of the common good, cannot be characterized as legal. But as some commentators have argued, this response seems simply to beg the question. We need more argument to conclude that a system is conceptually defective as law, as opposed to being morally defective, that is subject to moral criticism, if it fails under some test of sufficiently claiming correctness. For the moment, in this last section, let's bracket the questions and concerns raised earlier and assume that Alexy is correct that law makes an implied claim to correctness. What follows from that? Alexy asserts that the claim to correctness shows an ideal dimension to law, a necessary connection between law and morality, which in turn shows legal positivism to be mistaken. He elaborates that, quote, the claim to correctness necessarily leads to an inclusion of some moral elements, not only at the level of the application of law, but also at the level of determining the nature and defining the concept of law, end of quote. However, the asserted connection between the claim to correctness and the alleged rebuttal of legal positivism may be too quick. Consider an example that has already been discussed. Rawls combines a belief in law's claims to moral authority with a severe, exclusive form of legal positivism. Rawls thus allows one kind of connection between law and morality. In other texts, he has insisted there are, in fact, many such connections, but he still denies that there is a moral standard that must be met for a norm to be legally valid. It should be noted that Alexy at times seems to accept that the claim to correctness on its own may not be sufficient to refute legal positivism. He states in one text that this objective is achieved only when the correctness thesis is combined with two further lines of argument that are, by the way, he says, in part developed out of the claim to correctness. First, a Radbruch-style argument from injustice, and second, an argument about the presence of legal principles. There is no time here to go into the topics of injustice and principles. I have written at length about Radbruch and Alexy's use of Radbruch elsewhere, though. John Finnis offers a different kind of objection. He raises questions generally regarding conceptual analysis, as much as for those like Alexy who attack legal positivism on conceptual grounds, as for theorists like Rawls who would defend a legal positivist stance conceptually. Against Alexy, Finnis argues that difficult moral questions are rarely answered by conceptual claims. And this is his basis for objecting to both the claim to correctness and to the Radbruch formula. Finnis's view is that how officials and citizens should act in the face of unjust legal rules and unjust legal regimes, past and present, often raises issues both complicated and contextual, and that these challenges are either not helped at all or potentially resolved badly by simply asserting that certain rules and regimes are not law or no longer law. It should be noted that this objection may not be entirely fair to Alexy, who has made clear that at least the argument from injustice does not rest entirely in conceptual or analytical arguments, but requires normative grounds as well. By way of conclusion, I have tried to outline in this talk the ways in which there are difficulties, or at least complexities, in Robert Alexy's idea of law's claim to correctness. The inquiry takes us deep into the nature of simple communication, back out to what it means to have a theory about the nature of law, and also in the direction of wondering about the interaction of legal theory and practical reasoning, reasoning about how we should best act. The talk has offered reasons to question whether law in fact makes claims, at least in any straightforward sense. Even if one brackets that matter, there are reasons to raise doubts about what it is in fact implicit in the act of lawmaking. At one level, an act of lawmaking does implicitly assert the authority to act in that way, whether it also implies that the content of the action is morally good, or at least not clearly morally bad, is at least a harder question. However these matters are ultimately resolved, it cannot be doubted that Alexy's claim to correctness has raised an important argument in the debates about the merits of legal positivism and about the nature of legal norms. Thank you.